Start. Even if the clause is capable of two interpretation, we are inclined to choose the narrower interpretation for obvious reasons. Stop. Section 190 of the Code empowers any magistrate of the first class to take cognizance of any offence upon receiving a complaint. Stop. Or police report for information or upon his own knowledge. Stop. Section 195 restricts such general powers of the magistrate and the general right of a person to move the court with a complaint is to that extent curtailed. Stop. It is a well recognized canon of interpretation that provision curbing the general jurisdiction of the court must normally receive strict interpretation unless the statute or the context requires otherwise. Para. Now the offence under section 182 of the Penal Code, if any, was undoubtedly complete when the appellant had moved the Tehsildar for action. Stop. Section 182 does not require that action must always be taken if the person who moves the public servant knows or believes that action would be taken. Stop. In making his report to the Tehsildar, therefore, if the appellant believed that some action would be taken and he had no reason to doubt that it would not, the offence under that section was complete. Stop. It was therefore incumbent, if the prosecution was to be launched, that the complaint in writing should be made by the Tehsildar as the public servant concerned in this case. Stop. On the other hand, what we find is that a complaint by the Tehsildar was not filed at all, but a charge sheet was put in by the station house officer. Stop. The Learned Counsel for the state government tries to support the action by submitting that section 195 had been complied with inasmuch as when the allegations had been disproved, the letter of the superintendent of police was forwarded to the Tehsildar and he asked for calendar. Stop. This paper was filed along with the charge sheet and it is stated that this satisfies the requirements of section 195. Stop. In our opinion, this is not a due compliance with the provisions of that section. Stop. What the section contemplates is that the complaint must be in writing by the public servant concerned and there is no such compliance in the present case. Stop. The cognizance of the case was therefore wrongly assumed by the court without the complaint in writing of the public servant, namely the Tehsildar in this case. Stop. The trial court was thus without jurisdiction ab initio and the conviction cannot be maintained. Para. Chapter 11 of IPC deals with false evidence and offences against public justice and section 193 occurring therein provides for punishment for giving or fabricating false evidence in a judicial proceeding. Stop. Section 195 of the Criminal Procedure Code (CRPC) provides that where an act amounts to an offence of contempt of the lawful authority of public servants or to an offence against public justice, such as giving false evidence under section 193 IPC, etc., or to an offence relating to documents actually used in a court, private prosecutions are barred absolutely and only the court in relation to which the offence was committed may initiate proceedings. Stop. Provisions of section 195 CRPC are mandatory and no court has jurisdiction to take cognizance of any of the offences mentioned therein unless there is a complaint in writing as required under that section. Stop. It is settled law that every incorrect or false statement does not make it incumbent upon the court to order prosecution, but to exercise judicial discretion to order prosecution only in the larger interest of the administration of justice. Para. Now coming to the provision of first schedule of CRPC, section 188 of Indian Penal Code is covered under the said provision, which is declared as non-cognizable and bailable offence, and triable by the magistrate of the first class. Stop. Likewise, classification of offence against other laws in CRPC, it also describes, if any offence under any other law, if punishable for less than 3 years or with fine, which shall be considered as non-cognizable, bailable and triable by the magistrate of first class. Para. On perusal of the above said provisions, it is abundantly clear that the offence registered against the applicant under section 188 of IPC is non-cognizable. Under section 188 of IPC is non-cognizable in nature. Stop. Now coming to section 155 within bracket 2 of CRPC, which reads as follows: para. No police officer shall investigate a non-cognizable case without the order of a magistrate having power to try such case or commit the case for trial. Para. This section describes that no police officer shall investigate a non-cognizable case without the order of the magistrate having power to try such case for trial. Para. The provision in subsection 2 of section 155 of CRPC for asking permission of the court to investigate a non-cognizable offence is mandatory in nature. Stop. Therefore, the investigation of non-cognizable offence by the police without prior permission of the competent magistrate is illegal. Even mere accepting the charge sheet by the magistrate and taking the cognizance of the offence does not validate the proceeding. Stop. Even subsequent permission by the magistrate also cannot cure the illegality. Stop. As could be seen from section 460 of CRPC, these defects of non-taking permission before investigating a non-cognizable offence is also not curable. Stop. Though the charge sheet is filed after due investigation without prior permission of the court and that the magistrate has accepted the charge sheet and taken the cognizance, it does not mean to show permission is granted by the magistrate to investigate such non-cognizable offence. Stop. Therefore, investigation into the non-cognizable offence without written order of the magistrate is strictly contrary to the provision of this section. Para. This court further finds that the above said two offences are non-cognizable offences. Stop. Therefore, as per section 155 within bracket 2 of CRPC, the police have no right or jurisdiction to investigate the matter without prior permission of the magistrate, who has got jurisdiction to try those offences. Stop. Therefore, the entire charge sheet filed by the police is vitiated by serious incurable defects and procedural irregularities. Over.